information. So, well, hello everybody. So good afternoon and welcome to Scribes' 75th Anniversary Celebration and CLE program. My name is Michelle Jochner, and it is my true honor to be the president of Scribes, the American Society of Legal Writers, during its Diamond Anniversary year. On behalf of the Board of Directors, it is my great privilege to welcome you to this celebration of Scribes' 75th Anniversary. Today we gather not simply to mark the passage of time, but to honor a remarkable tradition of 75 years devoted to excellence, clarity, integrity, and purpose in legal writing. We have a fabulous program on tap this afternoon, having assembled a panel of national experts to discuss the future of legal writing in the brave new world of artificial intelligence. Our speakers represent a cross-section of our legal community and will share their views on this cutting-edge topic from the bench, private practice, academia, and ADR. They will also welcome any questions you may have, and this is your opportunity to tap into their expertise, so be sure to do so. We are also very grateful to our generous sponsors, my law firm, Schiller, Ducanto & Fleck, here in Chicago, the American Arbitration Association, and a trio of law schools, New York Law School, UIC Law, and Southwestern Law School. Thank you to all our sponsors for supporting this event and the work of Scribes. It is because of your belief in our work that after the panel concludes, we will have a reception to further network with each other and to celebrate Scribes' Diamond Anniversary. But to get started, what is Scribes? Well, we can turn to our mission statement for a quick answer. And that statement says, and I quote, "Scribes champions excellence in legal writing. Since 1951, we have promoted clear, succinct, and persuasive legal style and argument. We advance these goals through our publications, awards, outreach, and educational programs. As legal writing continues to evolve, we embrace innovation, guided by human judgment and accountability." But there's more to this story. Much, much more. Indeed, every organization has a story, especially one that champions legal writing. Our story begins with people who saw a need, continued through those who built on that vision, and now rests with all of us who will shape what comes next. Today, I'd like to spend a few minutes reflecting on our journey, where we've been, where we are today, and where the opportunities ahead may take us as an organization. So, let's start where every good story begins, with the vision that brought this organization into existence. Scribes is the oldest organization dedicated to improving legal writing. Scribes began in 1951 when Chief Justice Arthur T. Vanderbilt of the New Jersey Supreme Court invited a group of several like-minded lawyers to join him in an organization that would promote and pay tribute to excellence in legal writing. The membership was limited to members of the legal profession who had published at least one book or 3 articles on legal subjects. They also had to be nominated by an existing member. Now, before we go any further, let me tell you a little bit about Justice Vanderbilt, who was extraordinary in his own right. He was an attorney, legal educator, and proponent of court modernization throughout his career. While running a highly successful law practice, he became president of the American Bar Association from 1937 to 1938 and made reform of the administration of justice a top priority. In 1939, he helped draft the statute creating the nation's first body dedicated to judicial administration, the U.S. Administrative Office of the Courts. 2 years later, he helped draft the Federal Rules of Criminal Procedure, which were designed to, quote, "secure simplicity in procedure, fairness in administration, and the elimination of unjustifiable expense and delay," end quote. Now, Vanderbilt became the dean of New York University Law School in 1943 after teaching there on a part-time basis for nearly 3 decades. In 1948, he was appointed Chief Justice of the newly created New Jersey Supreme Court, and he used his position to restructure and to transform the state's court system. He was considered one of the nation's leading judicial reformers during the middle decades of the 20th century. Although he was twice approached to be nominated to the U.S. Supreme Court, and he declined both times, he was a mentor to William Brennan Jr. and was instrumental in Brennan's nomination to the High Court. Brennan then served for 34 years in that position. So, you can see that a vision of excellence was the key driver of the founding of Scribes by Justice Vanderbilt. At its first meeting at the Harvard Club in Boston, during the ABA annual meeting, kind of like at the same time now, right, for those of you who are at the ABA meeting, Scribes had 41 charter members, all men. A sign of the times, right? We can forgive them for that. They represented a broad cross-section of the legal community: lawyers, judges, educators, publishers, and editors. Over the years, membership steadily increased into the thousands, comprised of practicing lawyers, state and federal judges, law school deans and professors, and legal editors. Now, since our founding, recognizing excellence in legal writing has been a defining part of our mission. Over the years, we have broadened our awards program to celebrate achievement across an expanding range of categories. In addition, Scribes also created publications to promote excellence in legal writing, giving authors a platform to share their perspective while providing readers with practical tips for improving their writing. In 1961, Scribes established its annual book award to recognize outstanding works of legal scholarship. For more than 6 decades, that award has honored authors whose research, insight, and command of language have enriched the legal profession. And we will be awarding that award this December at our annual meeting. In 1973, Scribes began publishing The Scrivener, a quarterly newsletter offering a continuing forum for organizational news and practical guidance on legal writing and publishing. If you are a member of Scribes, you get to receive that newsletter every quarter. The following year, Scribes expanded its educational work through its Legal Writing Institute, continuing its commitment to helping lawyers and law students communicate more effectively. In 1987, Scribes established its Law Review Award, recognizing the best student-written scholarship published in a law review or a legal journal. The editors of every law review are invited to submit a copy of their best student-written note or comment. The entries are then reviewed by volunteer legal writing professors and then submitted to the Scribes Selection Committee. Another important and defining milestone came in 1990 with the publication of the first volume of the Scribes Journal of Legal Writing. Under its first editor-in-chief, Brian Garner, the distinguished editors and contributors who followed, the journal became an important resource for those seeking to improve the language and practice of law. Brian Garner was then a young University of Texas Law School instructor who had just published a new dictionary of modern legal usage. And a few years later, in 1995, he became the editor-in-chief of another dictionary. You may know it, Black's Law Dictionary. Today, he is recognized as a preeminent authority on legal writing and language, having authored more than 25 books on legal writing, including 2 with the late U.S. Supreme Court Justice Antonin Scalia. Brian also served as president of Scribes from 1997 to 1999. Now, besides works by prominent academics and practitioners, the journal has published pieces by many judges and other notable public figures, as well as interviews with 8 U.S. Supreme Court justices and many U.S. Court of Appeals judges. The journal has long been a leading voice on matters of legal writing and style, has been cited in dozens of court opinions and in nearly 1,000 articles and commentaries, and has found its way onto the pages of the New York Times, the Wall Street Journal, and Forbes, just to name a few. That same period also brought the development of institutional memberships in Scribes, allowing law schools and appellate courts to participate more fully in the work of our organization. The Scribes Brief Writing Award was established in 1996 to recognize outstanding briefs by law students in the very earliest stages of their career. Any law student who has won Best Brief in a regional or national moot court competition is invited to submit the brief so that Scribes can select and honor the best of the best. Another cadre of volunteer legal writing professors reviews all of those entries and submits the finalists to the Scribes Selection Committee. In 2002, Scribes instituted its Lifetime Achievement Award, honoring those who have had a lasting impact on legal writing through their jurisprudence, scholarship, and commentary. Among the recipients have been names that we know. The Honorable Diane Wood, Chief Judge of the United States Court of Appeals for the Seventh Circuit, and the Honorable Frank Easterbrook and the Honorable Richard Posner, also of the Seventh Circuit. The award also has been given to 4 U.S. Supreme Court justices: Justice John Paul Stevens, Justice Antonin Scalia, Justice Ruth Bader Ginsburg, and Justice Stephen Breyer. Our 2025 awardee was Lisa Blatt, Chair of the Supreme Court Practice Group at Washington, D.C.'s Williams and Connolly, who has argued 57 cases before the U.S. Supreme Court, more than any other woman in history, and has achieved a win rate of a truly incredible 81%. Wow. I was honored to be able to travel to Washington, D.C. last December to present the award to Lisa in person and to interview her on the lessons learned in writing and advocating before the nation's highest court. It was a very enjoyable experience, with Lisa sharing her very valuable wisdom as well as some great stories and a few laughs. And that interview is on our website and on YouTube, so you can find that there. It's a great 1-hour interview with Lisa, but we had a wonderful time. In 2007, the National Order of Scribes was created to honor graduating law school students who demonstrate exceptional ability in legal writing. This continued Scribes' recognition that excellence in legal writing should not only be honored at the later portions of one's distinguished career, but also encouraged, nurtured, and celebrated from the very beginning of practice. To that end, Scribes also developed new educational programs and resources targeted to members of Law Review. In 2022, Scribes published the Scribes Manual for Law Review Editors, a comprehensive resource designed to help student editors carry out their considerable responsibilities. The following year, Scribes held its inaugural National Conference for Law Review Editors, extending its educational mission to a new generation of legal writers and leaders. Scribes also created many webinars and remote programs to improve legal writing, not missing a step during the pandemic by continuing to present many timely programs, including a joint series with the American Inns of Court titled Right to be Heard, and the right is W-R-I-T-E, Right to be Heard, as well as a seminar on legal writing for the digital reader and interviews with the authors of our award-winning books. More recently, Scribes has reaffirmed its identity as an honor society, strengthening its connection to its traditions while preparing to address the challenges facing the next generation of legal writers. We have also expanded our board to include a broader range of perspectives from across the legal profession, ensuring we remain relevant to all facets of the legal world. Scribes remains connected to the institutions where the law's language is created, interpreted, taught, and practiced. And we are very proud to announce that in the past few weeks, we published Gems from the Scribes Journal of Legal Writing, volumes 1 to 20, an anthology collecting treasured essays, articles, and book reviews published in the journal's first 20 landmark issues under the guidance of Chief Editors Brian Garner for volumes 1 through 7, Professor Joseph Kimball for volumes 8 through 14, and Professor Mark Cooney, volumes 15 to 20. The publication of this anthology was made possible through the extraordinary generosity of Joe Kimball, who is on our board and had the vision to create this book, combined with the tenacity to work on it for many years until its recent completion and publication. Perhaps you met Joe on the way in as he was at the table where the book was displayed. If not, make sure to say hello to Joe at the reception and thank him for giving us all the gift that will keep on giving. I'd like to, Joe, could you please stand? You're welcome, Joe. And I would also like to recognize our Vice President, Mark Cooney, who is here too and was a chief editor of the journal. Mark. Well, that's a lot, right? That's a lot that we've gone through. We now find ourselves, though, on the threshold of a sea change in the practice of law and legal writing, shaped by the creation of artificial intelligence and rapid technological change. What was once only science fiction has now become reality. The term chatbot has entered our everyday lexicon, and our news feeds are filled with articles that trumpet the benefits of AI while also warning of the dangers. Generative AI can create text that mirrors human-authored content in a matter of seconds. Simply enter a prompt, and the program responds with a ready-made document. Headline-grabbing cases have offered sobering warnings that generative AI must be used with great caution, particularly in researching and drafting court submissions. The terms hallucination, misgrounding, and also sanctions are becoming everyday sightings. In fact, one of our panelists, Justice Rena Van Tine of the Illinois Appellate Court, just this week authored an opinion imposing significant sanctions on an attorney for these violations. A watershed moment for our state to remind practitioners that legal research and writing must always, always be balanced against human judgment and all that goes with it. The use of technology can increase efficiency and also be an important tool in the writer's toolbox, but that is what it is. It is a tool, one of many tools. But it can never replace the unique human touch of interpreting legal precedent and principles, formulating persuasive arguments, and devising a winning strategy. As you will hear today, the use of technology must always comport with the highest ethical standards of our profession. In the practice of law, trust is paramount, credibility is king, and reputation really, really is everything. Lawyers have the duty to represent clients competently and zealously by skillfully using their legal knowledge and expertise. Lawyers also have a duty of candor to the court to accurately present the applicable law and the facts of the case. Accordingly, attorneys' ethical obligations call for them to use their analytical and their critical thinking, contextual understanding, and professional judgment when performing legal research and drafting documents. These fundamental responsibilities cannot be abandoned to technology. In the years ahead, Scribes will continue to adapt to the emerging challenges ahead. And as our mission statement says, quote, embrace innovation guided by human judgment and accountability, end quote. We will continue to create publications and present awards and programs to promote clear, succinct, and persuasive legal style and argument. And we will continue to be a strong voice to champion excellence in legal writing. But we also plan to have a little fun along the way. We can't be totally serious all the time. So as shown by our upcoming Chocolates and Legal Writing CLE seminar, and I know you've seen it up there, you've got to register for this. It's on October 28th, National Chocolate Day. Taste amazing chocolates. Seriously, we will ship chocolates to you. Taste amazing chocolates and exotic chocolates while learning what they reveal about great legal writing. Give it a try. As we reflected on our past, considered our present. Well, I think there it is. See, that's register, right? As we've reflected on our past, considered our present, and looked towards our future, one thing becomes crystal clear. Scribes' greatest achievement isn't found in any single milestone, not in any single person, nor accomplishment or chapter. It is found in the story itself. And what makes a story remarkable is that it has no final chapter. Each generation has added its own pages, meeting new challenges, embracing new opportunities, and finding new ways to fulfill the mission. It is all too clear that the landscape will continue to change, and very quickly, as we have seen very recently. New questions will emerge, new technologies will reshape our work, and new leaders will bring fresh ideas. But if our history teaches us anything, it is that this organization has never been defined by the challenges it faced. It has been defined by the way it responded to them, by vision, innovation, and determination. Today, we are both beneficiaries of those who came before us and stewards for those who will follow us. The story we've shared today is not simply one worth remembering. It is one worth continuing. We do hope that you will continue to join us, or if you're not a member, to consider joining us, either as a member or a subscriber. We have displayed the QR codes that take you to the membership page on our website, or you can visit us at scribes.org, or you can ask anyone of us how you can take this journey with us together. Thank you so very much for allowing me the privilege of telling part of Scribes' story. The best chapters are still waiting to be written. In fact, today we write the first chapter of our 75th year and beyond. And that's today's program, The Future of Legal Writing, Balancing AI and Human Judgment. We have drawn together a panel of experts from across the country to discuss how generative AI is transforming how lawyers research, draft, revise, and analyze their work, and how we all can best harness this technology to strengthen legal writing without abdicating the core ethical responsibilities every lawyer must meet day in and day out. Our panel is moderated by Professor Kirsten K. Davis of Stetson University College of Law. Professor Davis is a recognized expert in AI, legal education, and the legal profession. And in addition to a JD, she also holds a PhD in human communication. Dr. Davis founded and leads a group of more than 500 law professors who are examining the impact of generative AI on legal writing education and practice. And she speaks to groups of practitioners and jurists across the country on this issue. Not surprisingly, Dr. Davis has received numerous awards for her work, the most recent being the 2026 Association of American Law Schools Legal Writing, Reasoning, and Research Section Award, which honors individuals whose work advances the field of legal writing. Now, there is so much more that I could say about Dr. Davis. Her CV is nearly 30 pages long, and as well as of our other panelists who are so very accomplished in everything that they have done. You can find more information on each of our panelists in our materials, and I know we have a QR code that has been going that you can click on that and you can see their full bios. Now, we will come back to Patrick Perry. I will tell you about him in a moment. Gretchen. There. Well, wow, on time. Okay. As we know, there have been some challenges outside with rain, Lollapalooza, ABA, and everything else on a Friday summer day in Chicago. But Gretchen Sperry, hello Gretchen, is co-chair of the Appellate Practice Group and a partner in the Chicago office of Gordon Reese Scully Mansakani. A former judicial clerk, She has represented clients in numerous state and federal courts of review, including the U.S. Supreme Court. Gretchen served as president of the Appellate Lawyers Association of Illinois and as chair of the American Bar Association's Council of Appellate Lawyers. Todd T. Sorrell, co-chair of Jenner and Block's financial litigation practice, is also here with us. Todd is based in Los Angeles and is a first-chair trial lawyer who has led high-stakes litigation, arbitrations, liability management exercises, and internal investigations across subject matter and jurisdictions, including, for example, as lead trial counsel in the workout, restructuring, and litigation of a publicly traded fund with $60 billion in assets under management. No sleepless nights on that one, right? Todd is consistently recognized as one of the best by legal ranking platforms, including the American Lawyer, 500 Leading Litigators in America by Law Dragon, the National Law Journal, Chambers, and most recently by the Daily Journal as California Lawyer of the Year. Kelly Turner, General Counsel and Vice President of the American Arbitration Association. Kelly brings extensive experience in comprehensive commercial litigation to her role and has developed particularly deep knowledge in the financial services sector and related industries, where she has worked extensively with insurance companies, mortgage loan servicing organizations, and clients in the payment card industry. Her broad litigation experience and specialized industry knowledge make her a valuable legal advisor in the alternative dispute resolution field, where she helps to shape the association's legal strategy and compliance framework. We also have with us the Honorable Rena M. Ventine, Justice of the Illinois Appellate Court in the First District. In 2001, Justice Ventine became the first female South Asian American judge in the nation to serve on a state court and has been a trailblazer ever since. She has served on several boards and is active with various bar associations, such as the Illinois Judges Association, the Illinois Judicial Council, the Chicago Bar Association, the Women's Bar Association of Illinois, and is a co-founder of the South Asian Bar Association. She has developed a specific expertise in the impact of AI on lawyering and is the current chair of the Chicago Bar Association's AI 2035 Executive Committee, which is tasked with examining the impact of AI on all aspects of our profession and which presented a comprehensive multi-day seminar on this topic. She also, as I mentioned, is the authoring justice of an opinion that was issued just this week that we will discuss that imposed significant sanctions on an attorney who abused the use of AI in his appellate briefings. And is that Patrick? All right. Well, we have to give Patrick a round of applause. Yay. Because Patrick's his flight was canceled, and he scrambled to find another flight so that he could be here with us today. So Patrick, wow, thank you so very much. Really, that's very, very, very wonderful. So Professor Patrick Berry, rounds out our panel. What perfect timing. It's perfect. So Patrick is the Director of Digital Academic Initiatives at the University of Michigan Law School, as well as a visiting lecturer at both the University of Chicago Law School and the UCLA School of Law. Professor Berry is the author of 12 books on various aspects of legal writing and teaches courses on digital lawyering, advocacy, digital lawyering, and advocacy in the age of AI. So, as I said, we have an incredible panel of experts, and let's welcome them all. Thank you, everybody. And now I am going to hand it off to Kristen, and so take it away. Thank you so much, everyone. Thank you.
Thank you for everyone for coming. Thank you to all of our panelists. Assembling a panel right on the fly is a lovely way to do it, and so we're glad to have you here. As I was riding the elevator at the hotel, just me and about 15 or so 20-somethings dressed for Lollapalooza, I wondered what this program would be called if it were a Lollapalooza band. Remember, the title of the panel is Scribes 75th Anniversary, AI and the Future of Legal Writing. So I did what I do these days. I asked Claude to help me. It researched the lineup of the band, and it made some suggestions. And the best one, I thought, was the Smashing Precedents. Now, I don't think this is that creative of a name. You might like to know that this is the first time since 1994 that the Smashing Pumpkins are appearing at Lollapalooza. Billy Corrigan, for those of you in my age group, is 59. So I suppose I like this best because this is the question before us. What is smashed about the precedents of legal writing, given that AI is in the mix or not? What is smashed? And that's what our panel is going to talk about today. So again, welcome. Now, we've seen a proliferation of AI legal drafting tools almost overnight, and we've seen an uptick in the usage of these tools. In fact, Clio recently issued its legal trends report that said 79% of legal professionals now use AI in their work, up from 19% in 2023. That's really an extraordinary increase. And I bet for my panelists, this audience would like to know what tools you are using in your practice that are AI. So let's do a quick show of hands. I didn't tell you I was going to do it this way, but I am going to ask you if you want to show your hand for the kinds of tools that you might be using for your work. So let me just go through the list. ChatGPT, Claude, Harvey.
I'm about to get a license.
Yeah. Clio Duo, that's a new one. Fastcase with Vincent AI. Spellbook. How about Lexis with Protege? And Westlaw Co-Counsel. And Gemini. And Microsoft Copilot. Okay. Anything I missed? All right, nothing.
Just like AI large language models to pull directly from Westlaw, which I still consider AI.
Yeah, so the large language models built into the Westlaw system directly itself.
Yes,
Yeah.
we don't have co-counsel.
Yeah.
Just like
in
Westlaw
Illinois.
AI.
There are
Right.
negotiations to get it so that we're
Right,
part
so
of the
none of
federal
us are
courts,
able to
but-
avoid, right, the embedded AI in the traditional tools.
But
Absolutely.
we can add that. I routinely use Grok and ChatGPT to make cards, invites, videos, PowerPoint presentations for various community and teaching obligations. But those are not
Oh,
used for
good.
work.
Good, got it.
And
Okay,
Q
that's a really
also.
important point to
We
make.
use Q also
Oh.
for note-taking for various bar association minutes.
Very good. Yes, I like to use those kind of tools too, the note-taking. That's a very good one as well. Now, Patrick, I promised you I would ask you a question to start, right?
Okay.
So since you just hopped off the plane. Since we are talking about writing, because as Justice Van Tine points out, there's a whole range of uses that I didn't contemplate in my initial question. Are you using AI inside of your word processor, like Word or Google?
Yes. So
Google Doc, I should say.
Some of the, especially the law-specific AIs, the Harveys, Lagoras, they have a way in which you can embed it into your Word documents, and then you can have a kind of on-demand editor as you're crafting instead of going back and forth between windows.
Anyone else doing that? The AI embedded into Word or Google Docs itself or another word processor in the AI tool?
I've used a tool called ClearBrief that we actually have available for our arbitrators, where it's generative AI pieces and also just non-generative AI machine learning, where it can summarize documents, create timelines, do site checking. And so I've done, if I'm in-house counsel, so I don't tend to write briefs, I just revise briefs that are written for me. And so I have run those through ClearBrief just to get a sense of site checking, and have done it for some of our internal investigations in terms of uploading a bunch of documents and having it create a timeline for me. And then our Word has Grammarly. We have a Grammarly subscription, which frankly, there's times where I'm like, no! So I argue with Grammarly a lot because I don't always agree with its revisions to my documents.
So I think what I hope we've established here is the ubiquity of this, right?
Yes.
Everywhere, all the time, hardly no matter what. So then that turns us to the question, and Todd, you're going to get the first question on this, about professional judgment. So the ABA and state ethics regulators have made abundantly clear in their guidance that lawyers may not cede their independent judgment to AI. Now what that means, of course, is a range of interpretations. And so Todd, how do you know the difference between using AI ethically for assistance and unethically delegating judgment to AI? How do you draw that line? Is there any part of your work thus far that you feel you can delegate to AI, meaning that it's automating the task that does not require some sort of judgment? Not that I've made that question more complex, but I invite you to
There are
pull that
several
apart.
subparts to
Yes.
that question.
Proceed.
Which one do I attack first? I love hearing the folks talking about embedded AI and how they're using it in their practices. My own personality, as well as the overall culture of my law firm, Jenner and Block, it is an exercise in restraint. It is an exercise in a non-delegable duty to the writing process, to the legal research and writing process. It is there's a view, and I share it. I advance it internally, which is that AI is a very good first-year associate, and you would not delegate or submit anything to any court. And I litigate cases, and so I'm in front of courts across the country and arbitral panels globally. We would not submit anything that is written by a first-year associate. It's a collaborative process, and you have to engage with it. So our perspective, or my perspective, is it's an exercise in restraint. I do not delegate any judgment to the tool. It's a tool, much like Google searching is a tool, much like when I first started practicing law and the BlackBerry was coming on. It's just simply a tool. It's a tool that helps me expedite. It helps me sometimes engage with legal substance well. It's sometimes a tool that helps me organize information well. I am in legal combat every day, and sometimes my opposing party will produce a bunch of documents on a Friday afternoon that I need to really understand because I'm going to cross-examine their expert witness on a Monday. Well, when you get 5,000 documents on a Friday afternoon at 4:59 p.m. for your 8:30 show time on a Monday, this tool is very helpful for organizing, very helpful for pulling out key information to be able to engage with that cross-examination. But for purposes of brief writing, motion writing, it is a non-delegable duty for the lawyers of my enterprise to ensure that we are exercising our professional judgment and getting at what we want to be is excellent in what we do, and I'm not about to turn that over to a internal or let alone an external large language model to tell me how to do my job.
So are there others that want to chime in on this idea of assistance versus delegation? Because it's often hard, I think, to find a definition or a line. Have you been thinking about that, what that looks like?
I think judges may use AI for assistance in a way that is similar to a lawyer's conservative use of it. So for example, here's a 200-page complaint. List all of the claims in the complaint. Or here's 10,000 pages of transcript with 20 witnesses. List by witness every page number where the word ice cream appears. List by witness every page number where the word chocolate chip cookies appears. List by witness every page number where both of those terms appear in the same sentence. So those are examples of tasks that are assistance. It doesn't really involve any judgment. Where you cross into judgment, which we do not do, is tell me whether the ice cream company or the cookie company has the stronger argument. Because the trouble is, you don't know what is the best or strongest. That takes independent human judgment. You don't want to be relying on a system of just pure pattern recognition. It might be better at recognizing patterns across the way, but just because there's a pattern of maybe 90% of the cases ruling one way, and it thinks I should rule that way, that doesn't automatically mean that that argument is right, just because it is repeated more either in your own internal system or under Lexis or Westlaw. So those are the differences. So and with you, Todd, there's no part of my work that I could delegate, that I feel I could delegate to the judgment part of it. That there's nothing I can delegate to AI in terms of judgment. I could shortcut inquire. So, for example, what is the most recent Supreme Court case law in Illinois on BIPA, the Biometric Information Privacy Act? It'll give me something, but I've got to realize, like, oh, it could be right, it might not be right. There might be some statute that passed that completely changes the interpretation of the law. And we cannot take that human context and judgment out of it.
So thank you, Justice. Gretchen?
Well, I think Justice Van Tine raises a really good point. And just to back up for a second, when we're talking about large language models, I think it's really important to understand what they're designed to do and what they can't do. So, Justice Van Tine, you mentioned, right, it uses historical documents. You don't know exactly what those documents are, but some database of historical documents to find patterns and predict, based on scanning all these gazillions of pages, what might follow in answer to your question. That's fundamentally incompatible with what we do as appellate advocates, as professional legal writers and legal analysts, when we're presented with unique sets of facts, a certain body of law that is confined, and applying the law to those facts in that context. That's not something that LLMs can or should help us do. We're answering questions that have never been answered, and so the sort of the backwards-looking approach that LLMs take just is inconsistent with what we do as legal writers of original material. So, because I really had to think about, I'm not like the Eeyore of AI. I think there's lots of very nice, very helpful uses for AI, but when we talk about legal writing, it's extremely limited and unfortunately very enticing to people to use, misuse, without understanding what it does and what it can't do.
So we have a couple more minutes on this topic. I'll push just a little bit to ask a couple other questions. So there are really some really interesting studies about humans' inability to create ideas, right? The idea of convergence, divergence and convergence. Lots of different ideas are hard for us to generate, but we're really great at choosing from them. And I think that puts into an interesting question the role of AI in generating options for legal argument. And I'm wondering if you have thoughts on that. So pattern recognition, right, it can recognize lots of different language patterns. If I am thinking through arguments and I use an AI tool to help me do that, do the panelists have thoughts on that? Not anybody is fine. Yes.
Okay.
If you like, we're making eye contact with you. If you'd like, or any of the panelists are great to have that.
Sure, and I think there are some ways that I use AI. For example, and I think you kind of led me right down this path, but preparing for oral argument, because another very important piece of information to understand when we're talking about LLMs is that it is some open. The database is open, we have no idea what's in it, we have no idea what the source material is,
And as appellate advocates, the strength and the robustness of our argument comes from how we use the source material, how we make analogies, how we distinguish, how we draw parallels between different bodies of law, things that without knowing where that source material comes from makes it very difficult. But what is helpful when preparing for oral argument is I can upload all the publicly filed briefs in the case and the trial court decision and the appellate court decision, and I can limit GPT's ability, based on just this information I'm giving you, ask me some, and here's the format of the argument, and here's the position I have, and ask me some questions, right? What could I expect the state Supreme Court to ask me about these issues that are presented? I will say that it has mischaracterized the holding of a case in one instance, but fortunately I knew the case well enough that I could spot it, but I didn't characterize the case that way, my opponent didn't, so I'm not, there's still some limitations in that way, but you can have a back and forth, kind of a dialogue, like, okay, well, this is what I say, now how would you respond? And so you really get to refine in that way, how to present the arguments, and help you structure, maybe the presentation of the arguments too.
And sorry, could I throw Tom under the bus a little bit? Not to highlight you, not throw you under the bus, because I know one of your colleagues, Adam Unikowski, has done like some kind of study, because he's an appellate court lawyer, also Supreme Court, and mostly I've heard him talk on a podcast about what he did, but it was long enough ago that I don't remember any of the details of what he said. But I think what he took was he's done it both ways. He's used it to help him prep and found it really useful in that regard, and that he felt well prepared for argument. But I think he also ran briefs through, I don't know which system, probably ChatGPT, and said, kind of like, how would you come out? And that it actually came out very similarly, I think probably drafted differently, but similarly to how the court actually came out in the end.
As long as it's not a draft. You don't want to upload draft work products into ChatGPT.
Well, if you have an enterprise version, you can, I would say.
Is it closed and encrypted?
Yes.
Okay,
Yeah,
so
yeah.
if I do something like that with a draft, I use co-counsel because it's specifically designed for,
yeah.
Exactly, it doesn't save any information, but okay, so, yeah, barring that.
Yeah.
Yeah, I mean, I think it would be helpful if it's, but if brief is draft, I guess it's just kind of, maybe it gives you confidence in what you've already done, but, sure, I suppose that would be, helpful input. But again, as long as, you know what it's based on.
Yeah.
I think that's.
There were different authorities, out there that I missed, for example, that wouldn't get caught in this kind of a pre-review.
Yeah.
Pre-filing review.
I think that shows, right, that difficulty of using and judging while you're using. That is, I think, what we're all trying to figure out right now. And because we started talking about confidentiality, I'm going to shift to that question before I go back and talk a little bit more about judicial expectations. But Todd, you're on for our first question here. So we've established that protecting client data is a significant concern, right? We just had that dialogue about what kind of tool. How are you handling that in your firm? Are you, when you're thinking about Rule 1.6, the duty to protect client confidences, which all regulators say that duty extends to AI, when you're feeding facts or draft language into the tool, anything that we should know that your firm is their view that they're taking on this?
Sure. We are careful. We have a duty to disclose in writing and get consent from our clients about what it is that we can do with their information. And then even if we have that information, Gretchen indicated, a closed system. It took my firm, because I was part of this process, a year to negotiate with Anthropic, which owns Claude, in order to get the right tool on our system so that it would be capable of being receptive of information that we might put in it that our clients, after disclosure and the receipt of that consent, give us for us to be able to do. It is, but once you get that consent and you're in that closed system, it becomes very useful to be able to engage with that process because you have to be humble. I don't think of every legal issue, like to think of myself as a pretty good issue spotter. I like to think of my colleagues who are much smarter than me as really good issue spotters, but we're often surprised by what AI will think about with respect to something. And again, it's back to that, it's a really good first-year associate. It's just part of the process. Back to the duty to our clients, it's disclosure, it is written disclosure, and it is written consent before, and sometimes it's modified. Well, what feature or facet of AI can we use? Are we able to take a document and put it in? We've created mechanisms so that we can do that because it's a closed system, but we're still very, very careful with what it is that we do. And we're very upfront with our clients about how we're going to do it, and nothing is ever done from the hip.
And I just want to point out for the group that in your materials for today, the Illinois Bar has a wonderful attorney's guide to implementing AI, and it's linked in your materials that talks a lot about the kinds of things that Todd mentioned, including the kinds of things you want to be thinking about in terms of choosing a tool and what to upload or not upload and getting consent from clients. So that's in your materials. Kelly, I was going to ask you a little bit about, in the context of arbitration tools that you are working with, what kinds of issues are you seeing around information given to arbitration participants to understand how their information is used in relation to arbitrations that might be assisted by AI tools? Because I know AAA is doing some of that with assisting arbitrators with new AI machines.
Yeah. So I'll talk about a couple of things. Oh, and first, thank you for Michelle for giving me an upgrade in my title. I'm actually Associate General Counsel, not quite General Counsel yet, but thank you. But so we have a couple of things. So first, we do have guidelines for our arbitrators of if you are thinking of using really any AI tool, you should be discussing it with the parties at the first preliminary hearing that you have, and getting, as Todd mentioned, getting their buy-in, getting their consent to what you're going to be using. It might also be good to ask them what they are using, but kind of our arbitrators are maybe a little, not less interested, but don't necessarily have the authority to be like, no, you can't use that. But also just having an open disclosure or an open discussion about that, and that if parties are like, no, I don't want you using literally any type of AI tool, then the arbitrator should be abiding by that. But also can use the explanation of, it's going to take me more time to get through your materials, even on the beginning where I can't use something to summarize, where I don't need to know every single fact, have to read every single page yet, because we're still at the start of the case. So I would normally use ClearBrief to create a summary, or Claude Enterprise or closed system to use to create a summary, and I'm not going to, so I'm going to bill you for that time. They should probably frame it slightly differently, but that's the gist, is that it's a time saver, and that if parties don't want the arbitrators doing that, that's fine, but there's a cost involved in that. And then we do make clear that arbitrators shouldn't be using generative AI for decision making, that there's a code of ethics for arbitrators in commercial disputes that applies to all arbitrators despite the name other than labor, and they have similar language. That decision making isn't delegable, so the arbitrator has to retain their decision making, and so they shouldn't be using AI to help them decide the case. I will say we launched almost a year ago the AI arbitrator, so it is a very limited in scope AI driven system where right now it's just construction, it's 2 parties, so 1 party per side. It's documents only. We don't think AI can hear witness testimony and ask questions or be able to make any sense of that. So it's documents only. We do have lots of arbitrations that are documents only cases. It is trained on our case data, and it interacts with the parties. So the parties upload their documents. It provides summaries and descriptions and some analysis, which the parties can edit at one point in time and then just give feedback on at other points in time. And then there is a person, a human arbitrator, who is appointed to the case, who the AI also assists with the analysis and even creates a draft award, but the human arbitrator can edit fully or partially or not at all the draft award. So ultimately, we look at it that the decision making is still the human arbitrators in the end, even if their decision is to keep the AI decision in full or in part. We've had people ask us of, when you're going to take the human out, and it can just go really fast. And so, and certainly, like, could the AI get it wrong? Yes. Do arbitrators get it wrong? Yes. Do lawyers get it wrong? Yes. Otherwise we wouldn't, and judges too, nothing personal, but otherwise we wouldn't have appellate lawyers and appellate judges. If everybody got it right in the instance and you're like, oh yeah, no, I lost and that was a bad case. And so there's always, there's that piece of it that's there. Our concern with removing the human arbitrator is twofold. One is we want the human to be making the decision, even if they are AI assisted in some manner. But also under the FAA and state statutes, very unclear whether the term arbitrator, when they're talking about awards that could be confirmed or vacated, whether that would actually apply to solely an AI-generated arbitration award. We think probably not. The FAA is 101 years old, so clearly wasn't drafted with anything in mind as to what's going on right now. Will it be updated at some point in time to allow for that? I don't know. There's also lots of legislation going on about AI, use of AI in a variety of different ways. A lot of it is more in employment or making decisions about consumers, like credit scoring and stuff like that. But there could be AI that ends up getting limited in terms of use in ADR or in other manners. And so we'll obviously comply with it, whatever laws come down. But so we have limitations and guidance for arbitrators, but then we also have this system that is very, very AI enabled.
We just have a tiny bit of time left on this topic, but it occurred to me to ask you, are you having issues with clients putting information into AI to generate, not necessarily documents that they give to you, but just thinking through problems that now become discoverable information, and what kind of advice or suggestions or conversations are you having with those clients?
I'll field that one.
Sure.
It depends on the client. Some clients go, use AI, they're very comfortable with it, they'll take the risk. Some clients are absolutely not. The most dangerous client that I have is the in-house counsel who will ask me a legal issue, and then a half an hour later will send me something and say, this is what AI tells me.
Yes.
And the client really doesn't want to do that, and I get the impulse, I really do, and I'm sensitive to it. But it actually adds the one thing that the client doesn't really want, which is cost and expense to their bill, because I have to respect what it is that they send to me, and it is often, I don't know, I'm a baseball guy, it's sort of 30, batting 330, mostly wrong. Particularly in what so much of what I do, which is in the context of multiple layers, structured limited partnerships or limited liability companies, as money sloshes around the globe and then cascades into the thing that actually creates the value and the return on the investment. A client who runs a large fund, for example, or a series of funds, and will put in an input, and they will get wonderful, great legal analysis in the corporate realm that has absolutely nothing and maybe 180 degrees away from what the result is in a limited partnership context, because limited partnerships are fundamentally different. And then of course there's the limited liability company context, which is this borrowed hybrid of corporate law and limited partnership law that's still developing. And Delaware does it better than Nevada, which does it better than Wyoming, and Texas is coming online and trying to get out ahead of everybody. What's the actual status of the law? So clients are not helping themselves when they drive something to me that they've generated on AI, and then some clients are they're very sophisticated, and they have very highly confidential information, sometimes highly confidential information that is that they're sharing with governmental agencies, and they're just absolutely not, whether it's a closed loop or not. No, hiring you and your smart lawyers. and your associates. So figure it out.
So let's turn to judicial expectations for AI-assisted submissions. Now, Justice Van Timeless, we'll start with you. As we've heard, more lawyers are drafting court documents with AI, and sometimes they are making serious errors. And we've already talked about how many times we've seen your recent opinion in the news as of late. The lawyer there was sanctioned for filing a brief that contained false quotations, non-existent case law, and fabricated statutory analysis and case meanings. My summary, not AI's. Your opinion artfully describes those, so thank you. I really encourage everyone to read this opinion. So what else are judges seeing, and their staff as well? What are you seeing with AI-assisted documents? And you've done so well describing the harms in that opinion. Are there any benefits, do you think, that you're observing yet through the court system?
Sure, we are seeing, I don't know if it's a benefit, but more of the filings have flowery language. Me personally, if it can be said to the point and shorter, I like it better. But I'm seeing things that it could be said in maybe 1 or 2 paragraphs, but it's taking 3 pages. So I don't mind. You know, maybe that flowery writing might be more persuasive to some other justice. But for me personally, it's not. I don't mind if it's accurate, if the cites are accurate, if the statutes are set forth correctly. So I really don't mind if the lawyer is using AI. I don't need to know about it. That's consistent with our Supreme Court policy. It just really comes in to become problematic when it is not used accurately. That whether it's a lawyer or an SRL, self-represented litigant, if they're not actually checking the source, if they're just relying on, you know, the summaries even of Westlaw, you know, I feel like about 30% of those summaries are just really off. I've had it where they're summarizing the dissent instead of the actual opinion, or they're putting all this dicta into it, or just because there are more hyperlinks for this particular issue, it's coming out stronger on one end versus the other end of the argument. So I would just caution lawyers to be cognizant of that and to really understand. I think judges too, we need to really understand how it works so that we can catch these issues sooner. There's no substitute for a lawyer that has the expertise. You know, otherwise anybody, like who needs a lawyer at all if you could just pop it into any of these systems, right? So I think that's where we have to be cautious too, where the younger generation especially, they're not trained the way we were when we came through the system. So we have a knowledge base. So it is incumbent on those of us who've been around longer to mentor people coming through so that they know that they can't just rely on it no matter how great it sounds. It has to be in the context of you know, your own knowledge and expertise in the field. So the filings that I see that have the most hallucinations tend to be the self-represented litigants. In our state court here, the state courts hear about 90% of the cases. And of those cases, there's a huge amount, something like 80% of people, just one side or the other, don't have lawyers. I mean, in our criminal courts, we have lawyers. You know, juvenile courts, we have lawyers. But a lot of people going through divorces or small business disputes, evictions, small claims court, they don't have lawyers. And on the one hand, it helps the access to justice because now anybody can just file a complaint. But then it's also harder as a judge to read the complaint and see, is there anything that's actually actionable? In the old days, everything was handwritten, and it was fairly quick. You could see, like, oh, you know what? Maybe this area they do have something to pursue, or you could read it and say, you know, there's nothing here. But now, because like so many things are written so well and with such detail, and then over and over again, we see these motions more in the trial court level, but on the appellate court too, that are very involved and written very well, but are kind of junk when you actually go through it. So I think that's where we have to be really, really careful.
Well, Justice Van Tine, I have a 17-year-old son, and I can tell you that every piece of writing that kids, instinctually they'll go to ChatGPT to have something written, and then they will put it through a separate program. I don't know what it's called, but
a humanizer?
Yes. Is this AI, right? There's like a percentage chance that this was written by AI. And then they'll tweak it and put it through again so that it doesn't, when the teacher finally goes to grade it, they're doing some sort of, analysis like that. But that's kind of default thinking. But maybe the court could do that with some, SRL
But
briefs.
it's no matter how much you humanize it, if it's wrong, it's
No.
wrong, right?
Yes.
If it's just made up, or if it's, if it's lifting things. I mean, the flat out hallucinations are the easiest to deal with. If it's like a case that just doesn't exist, okay, it doesn't exist. The more nefarious issues are, there's a real site, it's a real case, but the litigant or lawyer is saying the case is saying something that it really doesn't say. They're quoting, they're making up quotes, or AI is making up quotes from real cases, or they're paraphrasing it in a way where it's just clearly wrong. Or they may be using a statute that is decades old because AI hasn't shepherdized it.
And to build off of what you've been saying, just in the idea of these tools, my reading of the evidence, and we'll see if people agree with this, is that they reward expertise and they amplify incompetence, right? If you know a lot about limited partnerships, you can use these tools to leverage what you know and spot what is wrong about them. If you know nothing about limited partnerships, your lack of knowledge gets amplified because now you are producing more and understanding less. And I think that's the real tricky part about navigating these tools. They can be really, really wonderful for people who have a built-in expertise, and they can be really, really damaging for people who do not have the expertise and then will not develop that expertise because they're relying on the tool. And so one of the pitches I make to my students is, look, this is a time to develop expertise. This is a time where you can really nail antitrust or immigration law or limited partnerships and get a huge return on your investment. And it is also a time where you will potentially do a lot of damage if you don't develop those foundational skills.
Totally agree.
And I'll mention on the heels of Patrick's comment, we're seeing some studies come out of law schools on law students. There's a University of Minnesota study where they gave 127 upper-level law students documents to write, and they allowed them to use various ways in various experimental settings, including using a reasoning model, an older reasoning model than we're used to now. And I think one of the things that makes me think a lot about what Patrick is saying, what we're all saying, is that in that study, 3 of the 6 documents the students were assigned to write improved the analysis and reasoning in the document, not just the superficial expression nature of the document. And so we're dealing with this tension here about what will the machines actually do at the edge for improvement of novices.
And just to jump on that study, so I was part of that study.
Yeah.
One of it was the University of Minnesota and the University of Michigan, and we gave it to
I'm
this.
sorry, I didn't miss
No, I was like
Ohio
17th
State, so
author on that one. The lead authors were J.J. Prescott, Dan Schwartz, and Sam Manning. And so I was just on the caboose. But one of the really interesting things about that study was we asked the students to self-evaluate after going through. Some of them got to use AI, or with certain projects they got to use AI, and certain they weren't. And we asked them to say, look, did AI help you? And in many of the projects, it did help them. But even in the one that it didn't help them, they thought, oh, that really helped me. Which, super concerning, right? It would be wonderful if they were able to pick up on, look, I used this tool and it didn't go well, but it's really concerning when you use a tool, you think it went well, and then it actually didn't go well. That's a gap that I think is very, very unsettling.
Patrick's pointing out what I tend to tell practitioners, which is some of our problems in legal education are not exactly the problems you have in practice. Dealing with novices and training them is changing what we're having to do. Well, this is an exciting topic, but my job is to move us on. And I'm going to go to what I think might be the next most exciting topic for this crowd, and that is legal fees. I'm jumping ahead a little bit, panelists, we'll come back. And so I will be starting with Kelly for this one. And so the ethics rules make it abundantly clear that billing must always be reasonable, and reasonable unequivocally means when you are billing by the hour that you cannot bill for the time AI saves you, if any at all. This seems to be a popular topic, to the question being, is the billable hour dead? So my starting question for you, Kelly, is what challenges and opportunities does AI pose to ethical billing for legal writing, do you think? And what other ways are you all thinking about the billing structure in the future?
Yeah, I mean, it's interesting. So we do use outside counsel. We get sued a lot. We use it for other purposes too. And so far, I haven't actually seen. I've heard talk of some lawyers trying to kind of make up for the maybe saving time by using AI and having some kind of like AI overhead. And I know my old firm, we would do like Westlaw overhead when we couldn't bill for specific Westlaw charges, kind of depending on the client. And I don't know if firms have actually been getting away with this AI overhead. The firms that we've used have not done anything like that, and we certainly would push back on it. We also are a nonprofit, so we get to use that a lot, being like, you shouldn't bill this to a nonprofit. And I haven't seen anything that, because I do review, for the cases that I handle, I do review all of the invoices from outside counsel, and I haven't seen that there's any references to AI, which maybe they're hiding it, but I also haven't seen anything that seems like significant time savings on what we're doing. But I think a lot of the issues, what we're doing, and we are, in one of my cases, we are at the very beginning of discovery, and for sure we're going to use some kind of AI-enabled, and it might be just more machine learning AI, not generative AI, but AI-enabled document production, document analysis type of system. But otherwise, I don't see it, I haven't seen it as a huge issue, but I do think to the extent somebody is trying to, include like, well, it would have taken me 2 hours, it only took me an hour and a half, but I'm going to bill you for the full 2 hours because that's what it would have taken. Like I would absolutely not accept that.
Is anyone else looking at this? I'm thinking maybe Todd, given your role in the firm, you might have a sense of whether alternative billing structures are becoming more seriously discussed, or
Law firms don't know what they're doing here. Let's just be really honest about it. We don't know what we're doing. We're experimenting. We are trying to ask very good questions. One of the ways that we're experimenting at my law firm is working with Adam that you mentioned. We are hiring a junior, maybe third year level, maybe post clerk, but one lawyer in each of our offices who will work capable and qualified to be a general, but also has a background in AI. For whatever reason, they were just interested. They've been writing programming and code since they were 12, or they went to a law school. There are a couple of law schools in the U.S. Notre Dame comes to mind. Stanford is sort of obvious, where there's a lot of AI connectivity and training. But we are hiring a lawyer in each one of our offices that will work in a practice group, but also work directly for Adam, because we're trying to figure out how to validate. So much of what we're talking about here is validation. What are the inputs? What are the time savings? Nobody really knows, but superficially looking at it, a lawyer billing 2 hours because they say that they saved an hour on AI seems to me to be just morally wrong. And the idea is, if you are a good lawyer and a busy lawyer and the market wants your services, you will get more work because you are actually delivering faster results, faster analysis. So this idea of, you have to bill this empty time seems to me just to be clearly wrong-headed. I haven't seen it. That's not part of the conversation at my firm. We're trying to figure out how to create the model. Right now, I would consider us to be very much at the experimental level. We're trying to get local effervescence to figure out where this is going and keeping our ear out there for what might be working with others. But we're going to do it in a morally appropriate way, and it's going to take a long time of experimenting.
And to support, sorry, go ahead.
I think billing models are going to be changing. I mean, because we can't just have this, if it takes you 10 hours to bill on something, an AI, it only took, a half an hour to do it. We can't bill the whole 10 hours. That just, I think everybody here agrees that would be unethical. But then we still need the lawyer's expertise on it. So, it may change to a flat rate system. Okay, for this job, we're going to give you a flat rate of billing, because it's not only the time that AI took or the lack of time it took, but it's the lawyer's expertise that can put the final stamp of approval on it.
And sorry, go ahead.
No, please.
To support Todd's really good point about, look, if you're using AI, it's not that you're going to sit there twiddling your thumbs. You're going to get more work. And there's evidence in other professions of AI work intensification, of if my expectation is that what used to take you 4 hours is now should take you 45 minutes, then you're going to get more work. And also the idea of, if you feel like you're capable of producing more work now because you have this team of researchers, maybe you feel the pressure to keep doing that. And in a environment where lawyer well-being is already a big concern, there may be a risk of this sense of leisure that these tools are going to develop is actually going to be replaced by more demands on your time.
But also you mentioned something about, I forget what your phrase was, but the improper lawyers or civilians coming into the legal system. SR what?
SRL, self-represented litigants.
Okay, not something I'm familiar with in California, but I get the concept. There are reduced barriers to entry, right? Whether it's a flowery piece of a flowery complaint or not, the reduction in the barriers to entry to access the legal system, which is in many ways a closed box to people who never went to law school. There's fear around that. AI is going to break that down, and I actually expect there to be a multiplicity of litigation. Pick your subject matter, because AI can write your very complicated antitrust allegations well enough, maybe to get you, past a motion to dismiss. I don't know, but defense counsel are going to have to respond to that multiplicity of litigation because those barriers have been reduced. So I actually think that this whole thing is a boon to lawyers who are going to have to engage with this process, because there's going to be more, what I do, litigation around these issues.
Yeah, as a defense lawyer, can I respond to that? Because, even before AI, responding to pro se briefs, SRL briefs, is extraordinarily difficult.
Very difficult.
Understanding, you're essentially creating straw man arguments so you have a way to, assist the court, understanding what it is they're trying to say, and then responding to it. None of the stuff that we that we really want to be working on in that sense. But I think you're absolutely right, because I've got a case right now where just every day there's a new, in really, really like sophisticated kind of motions, like recall the mandate, stay the mandate, and this is from bankruptcy appeals to the Eighth Circuit. So like really specialized kind of stuff. And this, and I have every reason to believe that this woman is doing the research on ChatGPT and is producing the materials on ChatGPT, and it's very, very messy and very problematic. But even in the one thing I wanted to add to our discussion though about how we bill for this stuff is, even if I have a client who's a hospital, for example, hospital organization, they insist that medical records have to be summarized by AI and not by people. We're not paying people to do this anymore. We can do it more accurately.
What?
Yes, exactly. If it were me, I would say, well, I could never trust it. I'd still have to go through and verify, which I don't know if you can bill for that. If it's a client demand.
That's my body.
Sorry?
That's my body.
That's my well,
Body.
in terms of uploading it, well,
Privacy, yeah.
that's an excellent point too. There are closed, we talked about enterprise type systems, but you're right, if it goes into an open system, that's people's medical information. From a billing perspective, you still have to understand it. You have to verify if it's accurate, and you have to understand it. So even if you get, whether it's medical records or some other summary, you still have to analyze it to understand how it works within the legal framework of the rest of the litigation too. So it's not, you're still able to recoup that time, I think, from a billable perspective.
How many times, a question for you,
Yeah.
how many times do you think it will take a client to reverse course on that? Or how many times will they need to be sanctioned before they reverse course on that? Because I was in federal court in New York yesterday, and the judge was all over a very, very highly credible law firm saying, I'm sorry, you have to know the facts. And if your client
Right.
isn't giving them to you, you're not doing your job.
100%.
And so how many times does that conversation have to happen before your client, that client, says, okay, we can't squeeze this anymore?
I think the law firms are going to say, given the rapidly increasing severity of sanctions personally against the firm, exposing them to malpractice, ARDC beefs, right? I mean, the sanctions are extraordinary. I think that firms and the lawyers are going to say, I'm not putting my, just like in any other respect, your name is going on that, you're responsible for everything in it. If you're not going to pay me to verify or to, make sure at least that what we're doing here is fully accurate, we just can't service you in that way.
I know that we kind of pivoted away from the conversation, but I know I sent letters to my client. You just asked me to do these things. I'm not doing these things. Let me know if you want another lawyer.
Right.
Which, in some perverted way, they actually like.
Well, with that.
Well, yeah.
May I ask a follow-up question? To Justice Van Tine, we were talking about the potential increase in pro se filings, and there's some research coming out and some survey reports that, particularly in the federal courts in employment law, we're seeing a big increase in employment law cases that they, I think, are correlating to an increase in AI use from pro se parties. And I'm wondering if you're observing that at all in the Illinois court system, or if you can tell, or tracking it, and what kind of impact is that having at all on workload?
I don't know if they're formally tracking it, but we can see that there is an increase in pro se filings or self-represented litigants filing. And on the one hand, access to justice is important. People who cannot get a lawyer to take their case because it's worth too little, or they want to spend too much time on it. I mean, it's an avenue to get into court, and so it's very valuable to be able to provide access to justice to people who cannot afford it. But then the other side of it also is it is going to, and it does drive up litigation costs. If you have a lawyer on the other side who is billing hourly, that client is going to get hit harder for all these frivolous motions. The judges also have to take a lot of time to review everything and kind of painstakingly go through and separate what's fact and fiction from everything that is filed. So it does make it a lot harder to have so many self-represented litigants. In state court, I think we're seeing it more with the eviction cases. And that's also harder to sanction people who are about to lose their home. No lawyer will take their case, and the best they can do is come up with these AI hallucinations that aren't really taking them anywhere anyway. So I think many of us feel very hard pressed to sanction, a self-represented litigant. The lawyers, on the other hand, are in a totally different category. We have rules of professional responsibility. You've gone to law school. We should know when we're over our head and when we're not, and we have the responsibility to verify everything. So I see lawyers in a totally different category than the SRLs.
And I could just add to that, we see the same in arbitrations. We're seeing an uptick in filings, and we're also seeing an uptick within those filings of just the amount of submissions that the pro se party is doing before the arbitrator. We're also seeing an uptick of complaints being made, so most of the threats to sue us get raised to the legal department, so I see a lot of them. We're getting a lot of those, and they used to be just a paragraph of I should have won, this was bad, you need to give me a refund or whatever, and now it's a 3-page email that clearly generated from ChatGPT, sometimes even with the start of you should send them this, dear blank, and then let me know if you want to advise this at all. Could you not even take that out? But it would be obvious regardless, because oftentimes it's and they violated the Constitution, and they're a state actor, so you should sue them under 1983. I'm no, actually not. But there was one party who was threatening to sue us, had a case, federal court case pending already against the party in the arbitration, and so I went to go see, has he added us to that case? And he hadn't, which was great, but on one day, he filed 20 pleadings before the federal court judge. And I was oh, I feel that pain. And arbitrators see the same, but frankly, I don't think see that badly, but we get a whole bunch of things in, and I think it'll just, and I'm with you, in access to justice, it's good that people, and I've heard one judge say that she found that the self-represented, we call them parties, SRPs, but self-represented litigants using a generative AI tool can at least put together maybe more easily read pleadings of here's an actual cause of action versus, as you said, just a handwritten paragraph or a page where you're trying to figure out what they're actually alleging. But on the flip side, then they can assert a whole bunch of claims that have nothing to do with anything, and they can just keep on filing things or file really long complaints or motions or whatever that have no or very limited value in the end.
It strikes me that there's almost a paradox here, that the availability of lots of words to you will increase your access to justice, and at the same time maybe perhaps bog down the system from the additional text that must be reviewed to get to it.
And that makes it harder to determine who has the cases that we should really be paying the most amount of attention to.
Right.
I know there's at least one Rule 23 in Illinois that has come out against a self-represented litigant. The sanction was to just dismiss their whole case.
So panelists, if it's all right with you, I'm going to ask one more question that we can discuss, and then we can have 15 minutes to get questions from the group who I'm better excited to ask some. So I'm going to go to Patrick. I'm going to ask the one that's always interesting to me, right? The legal, the law school pedagogy and the problems with writing. And you know, we've been talking about, Patrick, the balance of AI and human judgment in the process of writing. And so from your perspective, having kind of been in on the ground floor of this, what knowledge, skills, and values do you think law schools should offer to prepare students for the writing process now? And do you think it'll be harder for law students to develop the kind of professional judgment we want them to have with AI in the mix? And then I would invite the panelists after Patrick answers to give us their points of view on legal education.
So my current approach, and I am very, very excited to potentially get some input on the wisdom of this approach, is to combine a lot of what we've been hearing from the panelists. So my current approach is to try to get them to become skilled skeptics when it comes to these tools. So you may have noticed at the initial question of how many tools you're using, my hand was up for all of them. That's not because I'm endorsing any of these tools, it's just I want to figure out how they're working. And I want to have an understanding of what are their strengths and what are their limitations. And I am pushing my students to have that kind of same sort of mechanical sympathy, is a term that is sometimes thrown around the programming world. I tried to track down the origins to it, and it is often attributed to a race car driver, a Scottish race car driver, Jackie Stewart, who said, look, you don't need to be an engineer to be a race car driver, but you do need to have mechanical sympathy. You need to know how this car is going to perform around turn 8. You don't need to build the carburetor, but you need an understanding of how the brakes are going to decelerate. And I find that with tools, the AI tools, that's the approach that I want them to have. But at the same time, I want them to have the restraint that Todd and others have really highlighted, of the skepticism, of really understanding what a good brief without AI looks like, so that you can evaluate whether the output is good. And so my approach is kind of both sides. One of the things that I have my students do as an assignment is I just have them read good sentences. And I want them to internalize what good writing is, so that they can do a couple of things. One is notice when the AI output is polished mediocrity, and that they could potentially improve upon that, but also retain that ability to distinguish themselves from what may be produced by many other people. If everybody can, with a subscription of $20 a month, produce the same kind of polished mediocrity, why are you paying $500, $900? Or if you're in the pro bono world, why am I coming to you for guidance? And so I am trying to, again, sort of build off this idea of this is a time to build expertise, but also be open that there's some technology that may help you leverage that expertise.
I would just add to that. I think we should put more resources into training law school faculty so that they're closer to Patrick's level of understanding, because the law professors, I think they need comprehensive workshops as well, and funding, because if they don't understand AI and the capacity of what it can do and what it can't do, how are they going to teach their students? And you're going to have students that are graduating who don't know all the tricks and trades and limitations of this tool. I'm also concerned about dumbing down the critical thinking skills of the students. And I think the Socratic method is really important in that regard, because anybody can put together great sentences using AI, but if you're called upon to actually explain your analysis and to be able to tell people about it, to engage with other students about it, I think that would be a good way to make sure that there's actual understanding and a development of critical thinking skills. And that's notwithstanding that the students do need experience with the AI legal tools that the law firms are all using too. We don't want them going out there and the first time they're using it is, like Todd can't be supervising every single,
I cannot.
assumption that comes through. They need to have some understanding going into it, because I think they need to be prepared going into the law firms and corporate legal departments, and also recognizing when AI is being misused against them. So, they should be able to recognize it when the other side does it too.
And if I could, just because we're all legal writers here, professional legal writers, I think, and I work with young lawyers now. I 100%, Patrick, I hope that your model becomes, the rule and not, this wonderful specialty. Because I think we absolutely have to do that. Like I said, as it is, high school kid, my son, that's sort of their first instinct. But from, a professional legal analyst, legal writer perspective, what LLMs are designed to do is automate processes. But as appellate advocates, the last thing I want to do is automate this process. The process of, reading material, taking in new material, synthesizing new material, finding different cases, that's all part of the process. That, we get 35 days to write a brief because probably 10 of them is spent just mulling over information when you're walking the dog, when you're in the shower, when, and then your 3 a.m. brain wakes you up at 7 in the morning. It's like, I got it, here it is, blah, 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 And so all of that is part of the process. I don't want to automate that process. And I certainly don't want young lawyers to automate that process because they haven't, you can't automate something if you don't understand, what's underlying it, which I think is exactly the point that you all are making, which is, if you can't spot the problems, you can't think critically about whether this is an accurate output or not. And so, as it is, it takes a couple of years. I bring associates on, that I trust in other capacities and work with them, and I have time then to kind of go through things with them and talk about the writing, sophisticated legal analysis, right? It's really hard to do anyway. And, and I think we're gonna lose that going forward. The other thing that concerns me is, again, taking the responsibility, if my name is going on this thing, I almost feel like if people are going to be using AI, I feel like it should be disclosed, like not as a courtesy, but like mandatory, like, hey, sorry, this is AI assisted, I, use this to come up with X, Y, Z, whatever, just so at least whether someone has used that, I think about that from a policy perspective, because I don't know, is this a firmish, should firms reinforce that so that the people out there that are going to stand up there and take the heat from the judges who are going to face the sanctions, who are going to get, their license impugned and their credibility impugned. I'm not sure what the best way is, but I think that also needs to be reinforced that this is extremely serious. If you're using tools, you're using them, even if you're using them correctly, great, awesome, you verified everything. But I think we still need to know, the assigners need to know that.
I think you've done a great job, panelists, of the kinds of things that we're really struggling with in law school. The one thing that you did mention that I think is a real concern is the assessment methods that we use. Out-of-class assessment, paper writing, those are all really in question in terms of their validity and reliability of knowing what is in a student's mind. And so many schools are really thinking about things like pairing written assignments with oral presentations and oral accountability, more in-class activities, more on-site proctored closed book examinations. It is an almost insurmountable number of issues for us in the Legal Academy. I think Patrick would agree with that. So thank you, panelists. Now, we've heard a lot today, and I wanted to give you all an opportunity. We have about 13 minutes or so left of our time. Or maybe we need to go a little bit longer, and Darby will let me know if that's true too, or Michelle will let me know if we can extend our conversation. But let's take some questions from the audience. Joe is already with his hand up. Are you going to stand, Joe, for your question? Or
well, if you want me to.
Look like you might. Yeah, okay.
You started to touch on this in the last round, and Patrick touched on it a little bit. But apart from the question of accuracy, do you think you can identify AI style? I mean, Scribes cares a lot about legal writing style, right? Do you think you can recognize it when you see it? And if so, how would you describe it?
I'm angry that AI stole my M dash. I was using M dashes.
We love M dash. We love M dash.
I think it depends, and I can right lawyer answer. I can more easily identify ChatGPT just because it has, I don't know, and I can't put it into words other than the M dash, which also my marketing team uses M dashes all the time. I do their review, and they're like, we think we might have to drop it. I'm like, no, keep the M dash, because they were concerned that people are gonna be like, you had ChatGPT write all of these. But yeah, it's just got a certain tone to it and approach to it, but I've started using Claude more recently, and to me Claude writes better, is more professional, and I don't know if I would be able to pick out Claude as easily as I would ChatGPT.
One of the best descriptions I have read of what AI writing is like comes from, I'm gonna mess up his last name, but I think his name's Adam Mastriani. He's a psychologist, and he said, it's as if the only thing that AI has read is LinkedIn. Because and some of the tells, Joe, I mean, the M dashes, there's also this construction which is wonderful in so many ways, but has now been tainted. It's not this, it's that. So one of my favorite commercials was back when HBO tried to really distinguish itself as not TV, and so they said, it's not TV, it's HBO, right? Like, we're a whole different category, which I think is brilliant. Justice Roberts has done this in his opinions, Kagan, all the really great ones. And then AI has taken this where if you go to any LinkedIn post or marketing that isn't so great, it has it's not this, it's that, right? Like, there's this category change. So there are tells, but I also have been persuaded by the evidence that suggests that it's really difficult to be 100% sure both on when it's being used and when it's not being used. So I take more of yes, there are certain tells, but I'm humble enough to, I've probably read stuff that I thought was, but I've probably been at both type 1 errors and type 2 errors. I probably thought this was AI and it wasn't, and I probably didn't think it was AI and it was. But that does really affect the ecosystem, because you're getting people who are really good writers not doing moves that they want, and that's it.
Could I just add one quick thing? What I find it's exceptional for is helping students learn style, because it can produce all kinds of different styles for you to interrogate and play with. And students are actually really good about identifying acceptable styles for professional writing and not so good, but one of the challenges has always been to get those examples in front of them easily, quickly, and have them working with them. And so I find it is a good style generator for the purposes of thinking through approaches to how you might want to put something together. The AI for me is a lot about different choices I can make if I know the questions to ask. And I think that's what we're training students now in a lot of ways, is the right questions to ask of any tool they use.
But we've all seen sentences from the very best writers that you just want to write on the wall. You know, I mean, it's just so good. You know, that the good writers can strike up. Do you see that from AI? I mean, a really brilliant sentence that you just say, my God, you know.
So again, it's technically brilliant in the sense of you can ask it to do an aphora. You can ask it to do an epistrophe. It can do haikus in ways that are amazing technically, but I think a number of people's responses to it, it lacks a kind of soul or voice, at least at this point, and that is something that I think is kind of wonderful, that humans still are able to produce something that, if not as technically polished, moves people. And I think if you're in the business of persuasion, that's a real fantastic thing.
One thing that's a hallmark, I think, of excellent legal writing advocacy, Justice Roberts, Justice Kagan, some of the best writers, is parsimony, right? The ability to say so much in the most concise sentence. That is not AI.
Yeah.
So I think the more flowery, right, the 3 pages to say we could have said it in a paragraph, that would probably throw up some signals for me.
One of the things that I don't see in AI writing, which I think is really important, and I don't think you're ever going to see it from AI, is empathy. you're not going to get the writing, for example, with respect to pro per. Cheddar Block has a rich tradition of pro bono, and so that oftentimes in that realm, there's a lot of self-represented lawyers. When I'm talking to my associates, we in many ways are litigating their case for them, so that when we're talking to the judge, we're revealing, this is what this is about, this is what it's not about, this is why this is important, you have to go this direction, Your Honor. And we think that their argument is really this, and we've met and conferred with them twice as long as we would normally meet and confer in a commercial context to show that we understand their position and here's how this needs to come out. You have to convey that in writing, that sort of empathy that you're really representing your client, but you're also making sure that there's some justice, not just some justice, that there is just justice, and that the judge who has a really hard decision is going to do the right thing when they're going to go against a self-represented person. You can't get AI to write in an empathetic way. You can't get AI to exercise judgment. We all know this, right? Intellect is cheap and judgment's expensive. AI is not giving you the judgment. You have to be able to know what this is in order to actually do the thing that I think we're supposed to be doing, which is getting towards some kind of a just result, even when the dispute's just about money.
So can I just add on to that? It's not directly on point, but in terms of the empathy piece of it, that Eric Posner of the University of Chicago did a study with somebody, and I'm not going to try to remember any details because I won't, but what they did is they used AI and actual judges, and it was like looking at a war criminal and his appeal of his conviction. And in one of the scenarios, there was precedent that required a certain outcome, and there was no sympathy for the defendant's scenario. Another was there was sympathy, but still binding precedent, and then sympathy but no binding precedent, and no sympathy, no precedent. Anyway, so lots of different, several different scenarios. And they found that the AI was just very strict. What does the precedent say? Can we follow the precedent? And that the human judges, where there was sympathy, even if there was precedent that required a certain outcome, they were like, well, but he feels bad now, or whatever the situation was. So the sympathy aspect of the human made a huge difference. And now you could argue whether is that good or bad. Like, should you be following precedent says you should be convicted for however many years? Should we be following that? And so that's not a question I'm trying to answer, but I do think that's just like evidence that the AI doesn't know how to do that or weigh that. It's just like, this is it.
Another question. Yes.
So, earlier in the panel, you talked about generating more ideas with AI. I think that's possible because all of you are so experienced and have such great judgment. Do you see younger associates more converging on an idea too early and then chasing that too far when maybe an experienced person would have just thrown it out?
Yes.
Isn't that an old problem?
Are you seeing more of that?
No. It's already at significant levels. They're just green.
Yeah.
They just haven't lived long enough. They just haven't encountered enough issues. And that's just the human aspect of this job, which is, at least in the private practice, why you have partners who hopefully they're promoted to partner because they've actually got some scars and they've lost a bit, and they understand, they're unbelievably crisp, correct, supported by stare decisis. This is and then we lost. Why? Equity. You have to develop judgment. You have to be able to gesture to the human component of what it is that we're doing, because that is often, particularly at the trial court level, where you're going to win or lose. And the associates who are super, super bright are just often wrong.
I would say from a practical perspective,
an associate who goes too far down the wrong rabbit hole without seeking some guidance is going to get their hours cut. So it only needs to happen once, maybe. But like any relationship, pre-AI, you're absolutely right, Todd. And it's like, let's bring me something, take a shot at it, bring me what you think, we should go, whatever direction we should go. But having those conversations early on just saves everybody.
I wonder if, because, and I think you alluded to it earlier in terms of one of the benefits of AI is it can be an incredible feedback machine, low stakes feedback. But I wonder if you've experienced less people coming to you because now they have a on-demand source of questions, answer, of that they would have brought this question to you, but they're now asking AI.
I sure hope not. I sure hope not.
Because
I don't know. I mean, if they don't, like I said, I work with associates that I already know,
Right.
but there are times I'm embedded with trial teams, and so we're doing, I'm working with the associates on the trial team. I don't know them, right? And so I'm very suspicious, right? I don't want to sign off on something not knowing, but I may not know. They may not want to tell me.
Because it's something that professors talk about, of the idea of we may be seeing fewer people coming to office hours. And maybe that's a good thing in the sense of if there was something small about the syllabus that you could ask the curated AI for the answer to, but if it results in reduced mentoring and that kind of relationship, that's a real concern. There's a technology writer, Neil Postman, he wrote about this when TVs came out. He said, look, technology isn't just additive. It doesn't take the world and just add something to it. It's ecological. It changes the environment. And so if you now have a tool that you can go to for advice, maybe you're not going to go talk to an actual person. It's not that you're going to keep those relationships and add this new component. It shifts the dynamic in the organization. I was curious if you've seen that at all.
I hadn't even thought of it that way, but you're absolutely right. But again, kind of running that out, at some point, they're going to realize that the information they got, the advice they got, wasn't right.
Right.
So, maybe it just takes reaching that point and being like, okay, well, I'm not going to make that mistake again. You hope that that's the way that it goes, but yeah, you also hope that they'll feel comfortable coming to you and working together and trying to answer the questions together.
I would suggest a really interesting article for review called The Tyranny of Paraphrase that is way older than AI by Mary Falk and Betsy Fagins from a long time ago. And I think it really puts this in play with AI today. And one of the problems that Fagins and Falk recognized in teaching was the inability to get students to talk back to cases. Right? In law school, we don't want you just paraphrasing everything. We want you engaging with it, thinking about it, being critical about it. And even then, not long ago, one of their struggles was to get, I think it's an early form of automation bias in a way. This authoritative text comes to you. Your job is to learn it, not to challenge it. And I think we sort of find that in an amplified form here now, is that you're getting text automated and delivered to you in a way that seems authoritative. And our demand to teach students to talk back to that text is more intense than ever. And whether they do that with or without our guidance, I'm hoping that we can double down on that critical thinking stance that you're so concerned about.
I think Patrick sort of nailed it a few minutes ago when he said he's trying to teach how to be a professional skeptic.
Yes, duty to doubt. Duty to doubt is what I call
That
it.
that is hard to do, particularly in an Instagram when your student body is all instant.
Yeah.
Yeah.
And also when ChatGPT is like, you're so smart, that was the best question anybody's ever asked me. And then you're like, I am so smart, and I was right. Well, you're totally wrong, and you don't. But you're right. You need to teach. So if you know that they're going to be using it with some manner, you need to teach them of enter your prompt very neutrally, not like, I think this is it, can you tell me I'm right, because it will, but enter it neutrally and then be like, what are other ways to look at this? What are ways that you're wrong? And know that you can have that conversation. If you're going to be asking it in the first instance, you should at least be having that level of conversation of challenge yourself, ChatGPT or whichever you're using, of like, don't just come at me with what you think I want to hear, and I'm going to challenge you. And then in a perfect world, you take that to your law firm, and we've done that, like I do that sometimes internally. I will look at something, like do a little, research. I always, when I'm doing either Chat or Claude, I'm like, show me your sources, and then I go to the sources. But even then, I'm like, okay, if it's something that's really important and there's high risk, I'm gonna go to outside counsel. But at least now I know what I'm talking about, because in-house counsel, we see literally everything. So like there was an immigration question and our immigration person was on vacation. And I was like, I know nothing about immigration other than it exists. And so I ended up, it was like, I'm sure, I'm smart, I can figure this out. And kept on, I was doing Claude and I was like, show me your sources. And it drove me to a US site that was last updated in March of 2023. Well, there have been a couple changes to immigration since then. So I reached out to outside counsel. It's like, I can't, and I told my business person, I was like, I can't reliably give you advice based on what I'm finding. And I'm sure counsel will be able to answer this question in 10 minutes, and I could spend an hour and still not really be comfortable. So I was like, I'm just gonna do that. But at least I had like a better understanding of the question that I was asking. Yeah.
So it sounds to me like, in many ways, critical thinking, everything old is new again, right?
Right.
Maybe amplified more than ever. Yeah. Well, thank you all. I know Michelle has a few things to do.
Before Michelle talks, I just wanted to say, and I will say it for myself, potentially for other people, I'll try to model the skepticism. I mentioned Jackie Stewart as the source of the, you don't need to be an engineer to be a race car driver, you just need to have mechanical zippy. I've never been able to verify that, so don't quote me in a world of hallucinations. I may have misquoted, so definitely fact check. It's certainly what I've said. They're probably much more trusting, but treat me as a version of a LLM that you don't trust with anything that I've said.
Well, wow.
Excellent.
Well, that's very good. And I'm going to just piggyback off of what Kelly said. If we would put this entire discussion into GPT, it would say, you are so smart, you are so smart, you are so smart. Because that's actually, everyone here. What a great panel. So Professor Kirsten Davis, Kelly Turner, Justice Rena Van Tine, Todd Terrell, Gretchen Sperry, and Professor Patrick Berry. Thank you for coming from both coasts to be here today to convene for this wonderful session. And I think we've learned a lot from everyone. I think that this conversation can continue. I know that we could probably go on to talk another hour or more about this, but we do have a reception that perhaps, or you could ask them some additional questions while they're still here. So again, I just want to say thank you to our wonderful speakers and to everyone who came today on a Friday in the middle of summer with all the challenges of Lollapalooza and every other thing that's happening in Chicago right now. So thank you for being here and joining us for this special day. Now, if you filled out a ticket for a door prize, go to the front desk to see what you have won. So there's little surprises out there for people who filled out their tickets. So please do that. And also make sure, we've been scrolling these things all the time, but I'm just going to remind you to fill out the evaluation. Okay, so that helps us know what we did great and things that we can improve in the future, and maybe even give us some ideas for future programming. So we'd love to hear from you about that. Make sure that you have the info for your own CLE credit, right, so that you can get credit for this hour and a half that you were with us. And again, as I said in my opening remarks, please join us in continuing to write our story for the next 75 years, either as a member of Scribes or as a subscriber. So, take a look at what we have up there, look at our website, talk to any of us how you can be part of our story. And then please think about our chocolate CLE on October 28th. That is going to be a fun CLE, something really, really different and very enjoyable. And there it is, as I say. So please think about signing up for that as well and join us for that. And if you have a book award outside, Joe Kimball is here. Ask him for an autograph. I'm sure that he'd be happy to do that for you.
No charge.
No charge. No charge today. Thank you to our sponsors for our wonderful reception that's outside. And let's party like it's 1951. Well, we'll go back. We'll go forward a little bit. But happy 75th to Scribes. Thank you for helping us celebrate our diamond anniversary. And we hope to see you at future events and that you can join us. We hope you enjoyed today's program. You found it enjoyable. And again, let's have one more round of applause for our wonderful program. Thank you, everybody. We'll see you out at the reception. Thank you so much.